From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The abortion drug mifepristone will stay on the market after the Fifth Circuit Court of Appeals stayed an injunction issued by a federal judge on the drug, but the case seems destined to reach the Supreme Court. Plus, Florida Governor Ron DeSantis has said he'll sign a pending Florida law that would ban abortions after 6 weeks, a so-called heartbeat bill. How will that play politically if the Florida governor decides to run for president? The law and the politics of abortion policy is our topic for today on Potomac Watch. And welcome. I'm Paul Gigot, the editorial page editor. I'm here with my colleagues Colin Levy and Kim Strassel. Let's take up the Fifth Circuit ruling first. Came in at a little before midnight on late Wednesday. And a 2-1 ruling overturned the national injunction over the mifepristone by saying that the plaintiffs, who are pro-life doctors, and Judge Matthew Kaczmarek, who had issued the ruling and the injunction, had violated the statute of limitations of 6 years for challenging an FDA decision to approve the drug. The original decision of approval was in the year 2000. The appeals court did not let stand the judge's injunction on FDA rules that had loosened restrictions on the drug's use, allowing it to be distributed by mail and to be distributed after 7 weeks of pregnancy instead of 10 weeks. So those restrictions in the Kaczmarek opinion, the injunction on those rules will stand. Kim, what do you make of this ruling, and where do we go from here?
I think it's certainly a more down-the-middle ruling than what the initial judge put forward, in that, as you note, he was using the fact that this had been reopened by the FDA in 2016 as a reason to say he had a right to take up this case, given the statute of limitations. But then he reached all the way back to the initial 2000 approval and blocked the drug entirely. And what the Fifth Circuit essentially said is, no, you don't get to do that. The statute is passed. But they did instead look at this 2016 decision by the FDA, and they made a number of substantive points, arguing that there were real questions about whether the FDA did that review appropriately. For instance, the Fifth Circuit noted that the FDA in 2016 had relied on safety studies that included some of the restrictions that it was actually eliminating. It also pointed out that in 2016, the FDA eliminated the requirement for doctors to report non-fatal or serious side effects, which undermines the FDA's argument now that there are no serious side effects because they had eliminated the requirement to report them. I don't know how the Supreme Court would look at this. This is essentially now coming down a bit to a brawl over the FDA's procedures. And there's different views on this in the court as to the extent to which the judiciary gets to second-guess regulatory decisions. We don't know if that's what the Supreme Court would look at or some broader issue about procedures and how this all works. But I think at this point that this may well be headed up to the Supreme Court, because I find it hard not to believe that the Biden administration won't take that route.
I agree with that, Kim. I think that both sides can find in this Fifth Circuit opinion something to dislike, which means that they have a reason to send it to the Supreme Court. The pro-life plaintiffs obviously prefer an injunction on all of the FDA approval for mifepristone. And then you have the administration, which wanted the least restrictive rules to be allowed. Then you also have the further complication that there's a lower federal court ruling in Washington state that came out last week that sided with the liberal plaintiffs who want state attorneys general, who said that the FDA rules were too restrictive. So the clashing of these circuit opinions, different views in two different circuits, is likely to add to the Supreme Court's decision to take this on. I think, Colin, one question is, will the court take it on an emergency basis, or will it let the Fifth Circuit injunction stand until the case goes through regular judicial order, which means the Fifth Circuit compromise that Kim described would stand? I don't know. What do you think? Will they take it on an emergency basis?
I'd be inclined, Paul, to just venture a guess that they would not take it on an emergency basis, that they would let this play out through the courts a bit more. I think what you have now is something of a more middle road, this compromise. And people who have looked at the Texas ruling on the legal merits, it really was a bizarre ruling on a legal level. You know, It was obviously the first time that a court has ever overturned FDA approval of any drug, as far as I know. And I think that's pretty dangerous territory. I'm not sure we really want the federal courts in the business of second-guessing FDA decisions or regulatory decisions in general. I mean, I think all of us can probably think of all sorts of ways that that could play out in a way that would just really muck up the system. And then you have other courts deciding what the other courts said and who's sort of fighting the decisions. I think the other part is that you need to show an injury in order to sue in federal court. And, Kim was talking about the fact that some of this may not have come out through the FDA approval process because of what the FDA expected. But even still, I don't think there's a lot of evidence that the mifepristone was causing harm. The drug has been widely used. It makes up more than half of all abortions and generally considered safe. So those are legal hurdles that should be taken seriously.
I'm going to disagree with you a little bit on one thing, Colin, because I think that I don't mind the courts interfering, second-guessing regulatory decisions by the federal bureaucracy when the bureaucracy exceeds its authority. When it rewrites a statute, for example, which I think the court has in its so-called major questions doctrine that they've laid out last year. In this case, it's not merely second-guessing the FDA's regulatory decision. It's basically saying, almost going through the facts of the drug approval and saying that it's second-guessing its analysis of the risks and the benefits of the drug. And Matthew Kaczmarek may be a brilliant man, but I don't think he has the expertise to be able to make that kind of decision, which is why no court has ever done this kind of second-guessing of the FDA, Kim.
Couldn't agree more. And that distinction is really crucial. I'm with you. There are so many places where the federal bureaucracy says, yeah, Congress didn't give us the authority to do this, but we're going to do it anyway, and we're going to come up with an idea. Or you have the administration, as we saw with its eviction ban or its vaccine mandate, reaching back into some dusty old statute and conjuring up out of one line some apparent authority to do something that's never been done before. Those are the things that I think the judiciary is entirely in its right and, in fact, should be brushing back those administrations and regulators. But this is very, very different. This is an authority the FDA clearly has. In fact, it exists to do this, to look at drugs, to evaluate how they operate, to monitor safety things, and to make decisions on the basis of that. And having judges step in and start imposing their own supposed medical knowledge in place of the folks there, it's very over the top and certainly a new thing. And something I think the Supreme Court would also be very wary of.
And that's my view, too. If they do take this up, I think I see at least 5 votes for supporting what the FDA has done here, or at least the process by which it went along with this. I'm not sure about Justice Thomas, Neil Gorsuch, Sam Alito, or Amy Coney Barrett, but I think the 3 liberals plus Justice Kavanaugh and Chief Justice John Roberts probably would go there. It's just something of a guess based on some of their jurisprudence. I don't know what you think about that, Colin.
I'm not really sure where the justices would go on this. As you say, there would be a lot that they would have to consider. I think one thing that I wanted to mention as we're looking at this more broadly with mifepristone, though, and the courts considering what they're actually going to do and how it will affect state-by-state abortion law in the country, is that the fighting over the abortion pill in particular is unfortunate, because I think whether or not you can mail it across state lines, whether or not you challenge the FDA approval, there's going to be plenty of women looking at what's happening right now who are quite eager to get on a road trip and get some and put that option into their own medicine cabinet. I think a lot of the sort of mix of political and judicial decisions that are happening right now are creating a lot of anxiety writ large among women who want to have that option. And I think that's what Republicans are contending with. And I think we have to be really careful about how much we accidentally create more demand for the product.
Well, and it's interesting because one of the arguments for years by conservatives, including our editorial page, was that if the Roe v. Wade is overturned, this would be returned to the states in the political process. And here now we have the abortion issue returning to the courts and the courts deciding on essentially what is a medical procedure, the taking of a drug. So I think that is something that also is unfortunate. I'd like to see this settled by politics.